Oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-5263 et al. Maxwell Goodluck et al. Versus Joseph R. Biden Jr. in his official capacity as President of the United States of America et al. Appellants, and case number 21-5256, Andi Gjoci et al. Appellants versus United States Department of State and Antony J. Blinken, the Secretary of State, and case number 21-5231, Antanina Sarakova Appellant versus Joseph R. Biden Jr. in his official capacity as President of the United States of America et al.
Good morning, Counsel. I hope I can be seen and heard in the courtroom. Welcome. And Ms. Alsterberg, we'll hear from you when you're ready.
Good morning, Your Honors.
Good morning.
May it please the Court. Kara Alsterberg on behalf of the United States. I've reserved 5 minutes for rebuttal. In March 2020, the COVID-19 pandemic changed the world. In response to the extraordinary challenges caused by the pandemic, the United States took common sense precautions to limit the spread of the deadly virus and deal with its impact. First, the President lawfully issued proclamations pursuant to 1182F, which barred plaintiffs from entering the United States. The Department of State followed its long-standing practice by viewing this bar on entry as rendering plaintiffs ineligible to receive visas. Second, the department issued guidance on how to resume visa processing within the confines of the limited operational capacities of the consulates worldwide. And the best way for the department to prioritize its resources was to focus on family reunification, which is very common sense, particularly given the pandemic. This case was spurred on by the pandemic, but it also exists squarely within the confines of the diversity visa statute, which neither guarantees a diversity visa for every selectee or makes it a requirement that the department issue all of its diversity visas in any given fiscal year. It is unfortunate that the diversity visa program was unable to operate as it normally does, but the pandemic has been a tragedy, and the lawful and common sense precautions taken by the United States to protect individuals from this tragedy should be upheld.
Could we start with your 1182 point argument? So your position that if someone is inadmissible, they shouldn't get a visa, makes a lot of common sense, seems to be right as a general matter, but it does also fly in the face of the basic statutory structure of 1182, which is you have one provision addressing conditions that will bar both entry and eligibility for a visa. And then you have a different section, which is the one you need to win, which is addressed only to entry.
1182F should not be read alone. It is also read alongside 1201G, which states that a visa may not be issued if the applicant is, quote, ineligible to receive a visa under section of 1182 of the INA or any other provision of law.
Which just brings us back to the question under 1182 of how it is we get to read F as bearing on visa eligibility when it just talks about entry and is not in the 1182A section, which covers both.
The district courts read this quote from 1201G as applying solely to 1182A, but that's not what 1201G states. It states 1182 in its entirety, which would.
No, it doesn't have to apply. It doesn't have to be read only to apply to 1182A. It could be read to apply only to those provisions in 1182 that have to do with visa ineligibility. And that's not just 1182A, because there's other provisions, for example, that allow discretionary waivers. So if you have someone who otherwise would be ineligible for a visa under 1182A, but the Attorney General decides to grant them a waiver under 1182H, say, then you'd have to consider both 1182A and 1182H to determine whether the person was eligible for a visa. So I take your point about 1182A not being specifically set out, but the decision to talk about 1182 writ large rather than just 1182A could be born of the need to take into account the waiver provisions that are elsewhere in 1182, which then seems to get us back to where Judge Katsas was.
And perhaps another.
Right, just a friendly amendment to that. The key language is not 1182, which might suggest writ large, but ineligible for a visa under 1182.
And the important aspect to also keep in mind is that 1201G also states or any other provision of law. And here we can also look at 8 USC 1101, which discusses that consular officers can issue an immigrant visa only to a non-citizen who these provisions confirm are eligible to lawfully enter for a visa. And again, this makes sense because a non-citizen who is not permitted to enter or is not eligible to immigrate would not be entitled to such a visa. And history has reaffirmed this for the Department of State time and time again, and Congress has ratified it time and time again as well. Looking back to pre-1924, which is the world that the district court's orders would take us to, there would be extreme amount of confusion at the borders. We would have consulate officers all over the world applying one set of criterion for individuals then to take long and arduous journeys across the world.
So that counsel, that argument I take that there's a lot of force to the practical complications that could ensue if people who mistakenly believed they could enter traveled across the world only to be reminded upon getting to the border that, I'm sorry, you just have a visa, you're not able to enter. That is well taken. But I guess my question is there no discretion at all under 1182F to process visas and issue visas, even in a situation in which the president and or the Secretary of State might conclude that it makes sense to do that, notwithstanding the existence of an 1182F order, which could happen if the 1182F order was a fairly short duration, visas last for 6 months. People could decide, well, actually it makes sense to process and issue visas. We'll give all kinds of reminders that doesn't mean that you can get in. But as a functional matter, it makes sense to process and issue visas, notwithstanding the existence of an 1182F bar on entry for a limited time duration. Is your view that that's a null set? That just can't happen?
Well, here that did not happen because of the confines of the pandemic and the language within these proclamations written by the president. Each of the proclamations at issue 10014, 1014.
But can I just ask you, we can get to the particular proclamations at issue in a second, but just, is it the government's position that that can't happen?
It could if the proclamation itself authorized the department to continue to issue visas, or if there's other language.
Why? How does that follow from your argument about the text of 1182F and the way we ought to construe that text?
The president has the discretion from 1182F to implement proclamations. That is the holding of Trump v. Hawaii, that discretion is great. But that is the president's authorization. And if the president is the one instructing the Secretary of State, as he has in each of these proclamations, he can create the confines of which the Secretary of State may decide to either, as it applies to visas, which is the language in these statutes, or otherwise, perhaps saying that it does not affect the issuance of visas. Inherently in proclamations that have that varying language, it's clear that the president recognizes that when he says the Secretary of State may may implement the proclamation as it applies to visas. The power the Secretary of State has is to withhold or refuse visas, not something that the Department of Homeland Security has, which is to refuse entry at the border. And that's reaffirmed again by the 2002 Homeland Security Act, which states that
it seems like a little bit of a different argument than I understood you to be making in your briefs, because I thought what you were suggesting is that the language of the statute puts 1182F orders in the same place as 1182A, and such that it just means that that a ban on entry means no visa eligibility. But I guess what it means is that's subject to discretion.
yes, and the text of the 1182F proclamations themselves, which here it provides that the Secretary of State at its discretion will implement this proclamation as it applies to visa, pursuant to such procedures as the Secretary of State, in consultation with the Secretary of Homeland Security, may establish, again, in the Secretary of State's discretion.
And do you read that language? It does refer to the Secretary of State's discretion, as you point out. Does that mean that the Secretary of State could have decided as a matter of discretion to process and issue visas?
And perhaps this is where things like the national interest exceptions do come into play. For example, on April 8th, the national interest exceptions were adopted by the Secretary of State for both 9984 and 10143, the regional proclamations, which then allowed for the.
Oh, I'm sorry. I don't mean exceptions that are within the proclamation that are already set out in the proclamation. I mean, the proclamation, as you rightly say, by its terms, gives the Secretary of State leeway to implement the proclamation with respect to visas. And could the Secretary of State have said, well, the leeway that I've been granted by the president includes the leeway to process and issue diversity visas. And I'm just deciding that I'm going to go ahead and issue diversity visas, even though I know that at least for the duration of the proclamation, there will be no entry.
That wouldn't make sense if the restrictions could not be enforced through the refusal of visas, as they were in these cases. The Department of State, through visa denial, is something that has been endorsed by Congress for decades. And consular officers have denied visas to persons barred from entry under exercises of the president's authority under 1182F. And this is also reaffirmed by the language of what an immigrant visa even is. As the Supreme Court recognized in Din, consular officers must screen non-citizens applying for visas for excludability or inadmissibility, not only the ineligibility criteria that's found in 1182A. Here, because the 1182F proclamation would bar the entry of these non-citizens, they were deemed inadmissible and excludable. And this is reinforced by the text of Hawaii as well, which states that 1182 defines the pool of individuals who are admissible to the United States, and held that any alien who is inadmissible under 1182 is screened out as ineligible to receive a visa. Here, the Department of State, through the 1182F proclamations, determined that because these plaintiffs were ineligible to receive inadmissible to enter the United States, they would be ineligible to receive visas. And this makes sense as well because the president uses 1182F in other realms of the world as well, whether it's human trafficking, human rights violations, or even currently President Biden has used an 1182F entry bar for certain officials of the Russian government who are harming and threatening the sovereignty of the Ukraine. By the district court's own interpretations, the State Department would be required to issue visas to those individuals if they were otherwise admissible, only to put the onus on the Department of Homeland Security to turn them away at the border.
All right, so there are three possibilities. One is that the State Department is required to process the visas in the face of an 1182F proclamation. Another is that they are prohibited from processing the visas. And a third is they have discretion to process them or not as they wish. I thought your position is that they are prohibited.
Yes, and that is the second position. I think perhaps to make it clear on the third element, it's just the language of the proclamation themselves can dictate that.
You started losing me a little bit. I think you answered Judge Srinivasan that there could be discretion, at least if it was baked into the proclamation itself. Is not the case here, but just to play that out, your statutory theory is that 1182 read in context of the whole INA and in light of the history of visa operations makes inadmissibility considerations just become grounds for denying visas as a matter of law. So I guess I don't see how you get the discretion, or how the president gets the discretion to sever an inadmissibility consideration from a sufficient ground to deny a visa.
And that kind of hypothetical is not at issue here, and that, it goes back to these proclamations do not set out that kind of potential severance. Instead, they fall within the second category of the three categories Your Honor laid out, which is that they afford themselves to the denial of visa issuance. And perhaps, again, looking to things like the Homeland Security Act of 2002, this makes sense again, because that provision that Congress ratified and specified states that nothing in this section shall be construed to affect any delegation of authority to the Secretary of State by the President pursuant to any proclamation issued under 1182F, which means, again, that Congress authorized the President to instruct the Secretary to assist in the implementation of an 1182 entry bar style of proclamation. The denial of visas to entry barred non-citizens is the only way that the Secretary could actually utilize itself in that scenario. And
so then, can I just get back? I'm still a little confused. Are there three categories or are there two?
I would say there is the one at issue here, which is the middle category of.
No, not at issue here, just as a conceptual matter. Is it possible to have a situation under your reading of 1182F under which the Secretary of State has discretion to process and issue visas in the face of an 1182F order?
And in that hypothetical, it would be something where the President himself in the 1182F proclamation specified that it would not affect visa issuance or language along those lines. Because, and in that scenario, again, that would only reaffirm the State Department's interpretation, because if the President had to go out of his way to clarify that it would not affect visa issuance, that, reaffirms that the State Department's interpretation that other 1182F proclamations are affected by the State Department's control of visa issuance in those cases.
So then it sounds to me like then there are, if I understood the architecture correctly, there are three categories. You think 1182F actually doesn't, as a matter of its own force, preclude visa issuance. It may is your view that it just sets a default assumption that an 1182F or proclamation bars visa issuance unless the President says otherwise? Or how does it work? Because I understood your argument from the briefs to be that as a matter of 1182F itself, visa issuance is just verboten in the context of 1182F proclamation by the President.
And that is the point that the government has made here, is that 1182F alongside 1201G, alongside a decade's worth of history of utilizing 1182F proclamations as the reason to not allow for visas to be issued to non-citizens. That is the whole point, that is the common sense here as well. There is also the visa lookout system, another example of Congress ratifying the department's longstanding practice.
What can you tell us about the origins and scope of the visa lookout system? It seems to me it would be very helpful for you if the visa lookout system were some comprehensive effort to make a list of every alien in the world who is ineligible. And the consular officer is supposed to check that list. If they're ineligible, no visa, and there's your connection between admissibility and entry. But it's a little hard to believe that's how it works, as opposed to just being a list of some finite number of known bad actors. Like, I mean, is it really the case that in the face of this proclamation governing every alien on planet Earth, that all those people were put in the visa lookout system?
Here, the visa lookout system is developed by the Secretary and includes exclusion lists.
Right.
An 1182F proclamation barring the entry of certain non-citizens, that being aware of those proclamations are what is part of that exclusion list, meaning that the Secretary of State and the consular officers abroad would know at first and foremost that these 1182 proclamations existed, applied to the non-citizens, and therefore they would not be eligible to receive a visa. And that would be the same information that the Department of Homeland Security would have at all of the ports of entry to ensure that it was the same criterion being applied in both places.
Is it entered generically? Just the lookout system says no immigrants may enter at this point, or no government officials from Cuba or whatever it is?
I am not certain of the precise language within the automated visa lookout system, but to the extent that the system has the exclusion lists, individuals who are excludable pursuant to the 1182 proclamations would be unable to enter and ineligible for visas at that point.
I mean, the language you give in your brief says non-citizens whose entry has been suspended through 1182F will have their names included in the automated visa lookout system.
So,
which is a great fact for you if it's true. It's just having a hard time understanding how this works, where the 1182 order is not targeting, leading officials of the Russian government or something, and it's just targeting would-be immigrants writ large.
and so long as the name of the immigrants are listed out, which, apologies, yes, that information is accurate, then that information would come from the State Department's own records as well. And the list of individuals in these cases, individuals seeking diversity visas and who have been selected as part of a fiscal year 2020 or 2021 process.
Can I just get back to the conceptual question one more time? I'm sorry to keep dwelling on this, but I want to make sure I understand the government's position on the interpretation of the statute. It sounds to me like the government thinks the following situation is possible. The president issues an 1182F order, excuse me, and the president decides that the president would like visas to be processed and issued during the existence of the 1182F order. And that seems functionally like that could be the case, because the president might well conclude, yes, I want a bar on entry. I need that for a time being, but I'm sufficiently confident that the conditions that lead me to think that bar is necessary will dissipate. And in the meantime, I don't want to bollocks up the issuance of visas because those are going to be good for 6 months. Let's just keep the pipeline going. If the president reaches that conclusion, the president could implement that, even though your reading in the brief seemed to indicate, in my view, and that might not be possible. So presumably the president would then issue a proclamation that would say, I'm issuing an entry bar, but I'd like the Secretary of State to continue processing and issuing visas, and it would put that in the proclamation. And you think that's okay under the statute. The president wouldn't be acting contrary to law under the statute. The president could do that, and then the Secretary of State, by order of the president in the proclamation, would then continue to process and issue visas. You think that's possible?
Yes, because there's also 1185A, which is part of the proclamations as well, which states that the president may impose any restrictions he may deem appropriate as well. The authority for these proclamations comes
right. That's language is in 1182F itself, right? The last clause of the first sentence says, or impose on the entry of aliens any restrictions he may deem to be appropriate. If that's where you're getting that from, I take the point. So that means that scenario is possible, notwithstanding what I understood to be your interpretation of 1182F. Now, suppose what the president thinks then is one step short of that, which is, I'm not going to direct the Secretary of State to continue to process and issue visas, but I want to give the Secretary of State discretion to do that. And I trust the Secretary of State. The Secretary of State needs to look at the system and decide whether to continue and process visas given the Secretary's assessment of the state of the consular offices, et cetera. I take it the president could do that as well. It seems to me that follows necessarily from the point that you just acknowledged.
These are potential scenarios, again, that are not at issue in this case.
Oh, I don't know that they're not at issue, but they're obviously hypotheticals. And it seems to me that I could be wrong. And please, by all means, tell me if I'm wrong. But I think that I understand that the president's authority to do the former, which is to direct the Secretary of State to process and issue visas, notwithstanding an 1182F proclamation, would subsume the authority to ask the Secretary of State to exercise discretion to determine whether or not to continue processing and issuing visas.
And potentially in a case such as that, there is the potential for there to be some kind of carve out for the Secretary of State.
Okay, then why isn't that exactly what happened here? Because I completely take your point about the language of the proclamation, which in the relevant clause directs the Secretary of State to implement the proclamation with respect to visas. The straightforward way to read that, it seems to me, or at least a straightforward to read it, is Secretary of State use your discretion to decide whether it makes sense to continue processing and issuing visas. It just seems like that's exactly what it says.
And the Secretary of State and the Department of State, looking to history and the long-standing interpretations of 1182F proclamations in the past, read that to mean, as it has in decades past, to mean that they could refuse to issue the visas in these cases because. But
if that's the way it worked, then that would be an exercise of discretion by the Secretary of State. Whereas I think everything you've pointed to in your briefs, understandably, and as I read the challenged secretarial policies, they don't purport to make a programmatic decision. They say that by virtue of the 1182F order, by the statute itself, I don't have any discretion. That means that visas can't be issued. It wasn't an exercise of discretion. It was just a conclusion that the statute mandated, which I thought was your original argument. But now we're in the land where that doesn't have to be the case. And in that situation, it seems to me that you would want some exercise of discretion. And I don't see that. I don't think. What I see is the Secretary, in concert with the argument that I thought was in your briefs, reading the statute to prohibit the exercise of discretion to issue visas.
The statute itself does state alongside 1201G that visas may not be issued to applicants who are ineligible to receive a visa under Section 1182. These read in tandem can only provide the common sense reading that under 1182F and 1201G, visa refusal is the common sense reading. And again, this also applies to Hawaii v. Trump, where the whole point there was a proclamation issued to improve visa issuance processes. And it would have made no sense for the State Department in that scenario as well to issue visas in any form. And again, human rights trafficking, human rights violations, human trafficking, or other instances by the district court's reading would require the Department of State to nonetheless issue visas to individuals who would otherwise be ineligible to enter the country. the Secretary of State and the Department of State need the ability to ensure that the criterion that they're looking at is the same as the criterion that the Department of Homeland Security is looking at. And this common sense reading on its face is what allows for the refusal of visas.
I think there's a lot to the common sense notion. I don't deny that. I guess the question is whether the common sense notion requires an exercise of discretion that shows that this is the common sense solution, or is it that the Secretary thinks, as I read the policies to have done, that there's not even an exercise of discretion here. It just has to follow from the statute, which your argument today already, I think, allows isn't the case. It doesn't have to follow from the statute. But anyways, I'm dwelling on something that we've been around. I don't mean to sidetrack the argument.
Yes, I see that I've gone into my rebuttal time. I'm concerned if there are additional questions on 1182F at this juncture, or whether.
Why wouldn't, if there is such discretion, why wouldn't we read it into at least the first order was effective for 2 months, I believe, which is a relatively short amount of time compared to the 6-month visa window. Why wouldn't we read that as at least allowing for the possibility that continue to process the visas? The suspension is only going to be in effect for 2 months.
Again, because 1182F on its face and the longstanding and historically ratified components of the State Department's 1182F interpretation would mean that the State Department would not issue visas, even if it is just a 2 month.
I mean, but that's just back to an argument, the argument you made in your brief, which is that the statute prohibits this.
And here, each of these were extended. The pandemic was an unknown reality at that time period. In the Gomez litigation, from the very first proclamation through the end of the fiscal year, the proclamation was extended through the end of the fiscal year. There was no reason to think that these would not continue to be extended as the pandemic continued on as well.
Can I just follow up on Judge Katz's question? And we will get just a couple of other issues. Thank you for your sensitivity about the time. But as I read the proclamation, the original the main proclamation, which is 10014, it says in section 3, the Secretary of State shall implement this proclamation as it applies to visas pursuant to such procedures as the Secretary of State, in consultation with the Secretary of Homeland Security, may establish in the Secretary of State's discretion. That just seems to me to give the Secretary of State discretion to do exactly what we were talking about earlier, in which I think Judge Katz's question was getting to, which is to decide whether to continue processing and issuing visas or not. That language seems pretty good. It seems like exactly what Judge Katz's question laid out, which is why wouldn't the proclamation be read to give the Secretary of State that discretion in that sentence? It just says that.
Yes, and perhaps this is also why the department's interpretation should be entitled to the Skidmore power to persuade standard. The Foreign Affairs Manual has been around for decades. In both 9 FAM 302.14 and 9 FAM 301.41a, each describes ineligibility based on sanctioned activities to include 212F, which implicitly indicates that the department treats a prohibition on entry under 1182F as a condition that renders an individual ineligible for a visa. Likewise, under 301.41, the department looks at 1182F as a ground for refusal. These that
would be, I think, a compelling exercise of discretion if discretion were exercised, and it would be one that would draw. I don't know about Skidmore deference. People have different views on exactly what that entails, but I understand that if the Secretary of State exercised discretion and reached a determination, then we would give due consideration to the Secretary's thinking in doing so. But here, by your own argument, there was no exercise of discretion. It was just a conclusion that the statute forbade the issuance of visas. And the April 28th statement released by the Secretary just says that. It just says in paragraph 3, the issuance of many immigrant visas was suspended by presidential proclamation, which is exactly the argument you made in your brief, which is that there's just no choice. There wasn't an exercise of discretion. There wasn't a policy-making decision. There wasn't a taking into account of common sense considerations. It was just a legal conclusion that because the 1182 proclamation issued, end of story, that means visa issuance is suspended, notwithstanding the language we were just talking about, which gave the Secretary of State discretion seemingly to decide what to do with visas. The Secretary of State concluded there actually isn't any discretion on this issue because it just means I have no discretion. I can't issue visas. The proclamation issued, end of story.
And looking to even the impetus for these proclamations, though, it is the pandemic. And this can't be looked at discretion in a vacuum. This is discretion at a time when the whole world was shutting down and in-person contact would potentially lead to grave illness or death. And perhaps this is also tied into the prioritization scheme that the department had to craft during that time period as consulates worldwide, each for
That's a great argument for not processing visas, but it's not the argument made to support the administrative orders that we're reviewing.
And
the rationale asserted by the agency was 1182F prohibits us from doing this, period, stop.
But the agency did look to history, look to pre-1924 and the various other proclamations that have been issued throughout the year.
In order to reinforce the point that the statute prohibits issuance of visas.
And in those like scenarios, it should and did. And again, that is why the common sense prevails in this case as well, and why those reflect the State Department's interpretation here as well.
Can I ask you, I don't want to cut off lines of questioning that my colleagues might have on other issues. I wanted to see if we could shift to the issue about the authority to grant relief to the particular plaintiffs, notwithstanding the lapse of the fiscal year.
I'm down on Q1.
Thank you. So if we can shift to that issue, Ms. Alsterberg. So one question that I have about that argument by the government, and again, I understand the force of that argument. I understand the argument under the text of the statute, and the Judge Easterbrook's opinion from the Seventh Circuit is usable for you for that purpose. My question is a practical one. Does that argument mean, for all practical purposes, that the Supreme Court could never review a question about diversity visas? Because under the Supreme Court's normal time track for granting and considering a case, the fiscal year would have ended if it's an issue about diversity visas, and then there would be no ability to grant relief, so the case would be moot. End of story. It never gets to the Supreme Court.
Yes, that would be the case, because the remedy would come from Congress. This is a separation of powers issue. This is historically looking at examples where Congress has acted in the past, whether it be administrative errors, embassy bombings, or even 9/11. Congress has stepped in and taken diversity visas from the next year's allotment, even though there may have even been leftover diversity visas from those prior years. It is Congress who can provide.
That seems like a pretty extraordinary result. And you're, of course, right that Congress can decide in particular cases to enact statutes that provide relief, as they have done in a handful of occasions. But to read a statute as Congress intending to preclude individuals from getting relief, even if the Supreme Court concludes that the way the statute has been read is wrong, the Supreme Court would be disabled from doing anything about it, period. There's nothing the Supreme Court could do to grant relief. even though the Supreme Court by hypothesis would conclude that the way the statute has been construed and applied is just lawless.
The construction of the INA also supports where diversity visas fall, though, as well. Everywhere in the INA, the mission of the State Department looks to family reunification, and there are timetables about requirements for the speed in which the Department of State must process immediate relative and fiancé visas within 30 days and family preference cases within 60 days. And here, diversity visas are just simply not put on the same footing, and the relief that would come from Congress.
Can I ask one follow-up question, which is in the Seventh Circuit's opinion, the Shahi case, the opinion hypothesized that this point was a statutory defense that the government could waive or forfeit. And if that were so, then that would be a potential route, even if it's by the government's discretion, that would be a potential route to keep a case alive for purposes of effective relief, because the government could decide that it wants to forfeit the point or just affirmatively waive the point to get a legal answer to the underlying statutory interpretation question that by hypothesis is an issue. So do you take issue with that part of the Shahi opinion?
Yes, to the extent that 1154A by law sets the deadline, September 30th, midnight.
That's to the full extent. In other words, that's not a caveated answer. You're just saying you think that's wrong, that it was wrong of the Seventh Circuit to hypothesize that this is a statutory defense that the government could waive or forfeit. You think it's non-waivable and non-forfeitable.
Shahi also looks to this as a merits issue, though, and that seems to be on point for the Department of State's position as well.
But even if it's a merits issue, I guess just to get a complete answer, that you think a merits issue can be waived or forfeited. And so even if we assume that it's a merits issue rather than a jurisdictional one, your position is that Shahi was wrong to think that the government could waive or forfeit the argument that the end of the fiscal year means the case is over. You think that's not waivable or forfeitable. It just is.
Yes, to limit, if Shahi is seen as limiting the statutory text, the plain language, then yes, there could be, the government would not agree that it could be waived in that scenario. And the issue with the district court's opinions here and why we're here today is the overbroad reading of this circuit's decision in al-Makrami that leaves open that.
Before we get to that, let's just tie this down. Why the statute could be as mandatory and clear as can be in your favor. You could still choose in litigation not to assert it. The only thing that would prohibit you from doing that is if this statute went to a court's subject matter jurisdiction, which I don't see how it possibly does. It's just a substantive rule about how the program resets every year. It doesn't say a word about our power to adjudicate that.
Well, inherently, the eligibility for a diversity visa also expires that night. And the district courts here in what they perceive as their equity have attempted to overcome the statute and extend that eligibility. But simply because one could attempt to reserve the visa numbers before the fiscal year end does not negate the fact that
No, I understand that, but that's your argument. That's your argument on the merits against what the district court did here. I'm just not sure why you're resisting Judge Srinivasan's suggestion that you could choose to waive this in litigation, which is actually a friendly question for you because it gives a means for teeing up Supreme Court review if the government wants it.
Perhaps there are scenarios where this merits issue could be waived in litigation for the purposes that are not at issue here. It was not waived here. This is a merits issue here. The district court's orders are problematic. and have grave impact on the separation of powers in terms of providing relief that should be provided by Congress if Congress chooses to do so. And again, rely on that overbroad reading of al-Makrami, which just returned the case as not moot, not decided that you can reserve and then unlawfully adjudicate in a fiscal year in which the statute clearly provides not.
How would you handle the line of cases in this court in which we have asserted a power to suspend operation of statutory lapses of appropriations? That seems pretty analogous, right? There's a statute that says the pool of money is available until September 30 and no further. And we've asserted this extraordinary power. The litigation is filed before September 30. We just think we can turn that statute off, that deadline off. Why is this any more aggressive or edgy or creative than that?
Money is fungible, and these diversity visas are not. There is no way to suspend. There's no option for suspension under this statute. These visas and the eligibility for the diversity visa selectees does not expire.
No, but I mean, we're asserting an equitable power to overlook a statutory deadline in furtherance of our ability to give relief in a pending case. That seems common to the appropriations cases and what the district courts did here.
Maybe it's also important to note that the diversity visa selectees each year are also over-selected in inherently choosing who may or may not get one of these diversity visa numbers. The courts are micromanaging the State Department's own authorities and how it randomly selects diversity visa applicants each year. In the fiscal year 2020 case, there were over 90,000 plaintiffs and beneficiaries vying for one of the 55,000, and in 2021, there were over 130,000 selectees. An individual is not eligible to make the application until they have that in-person interview, and until such a time that eligibility also does not exist.
If we slice the issue in the following way, can you let me know what the problem is? And which is that so let's just hypothesize, I know you resist, but let's hypothesize that the district courts and the courts have some power to grant effective relief, notwithstanding the end of the lapse of a fiscal year, and by doing something we'll call reserving visas. But reserving visas doesn't mean that the State Department has to adjudicate. It just means that the State Department just doesn't rely on the lapse of the fiscal year and then pretends like the relevant fiscal year is still in place, and then just processes the paper that it has before it, however it otherwise might, which includes all the discretion that the State Department always has when in the same situation as if it were in the middle of the fiscal year. So it could include the discretion not to grant an interview. That discretion exists, but just what it means is it can't do whatever the legal flaw would have been that causes us to send it back. Here, by hypothesis, it could be something like there was no exercise of discretion under 1182F. So this policy was wrong, we send it back, but that doesn't mean anybody has to get an interview. What it means is that it sets everybody back exactly in the same position they would have been in, including the State Department, which is it gives the same degree of discretion other than to say that the lapse of the fiscal year means that this application is over. Would that scenario be workable if we concluded, and I know you've got a lot of arguments otherwise, and I'm not saying that I've necessarily concluded that, I just want to play out the hypothetical. If the court were to conclude that there is some power to grant effective relief by the Supreme Court or by lower courts in these kinds of situations, notwithstanding the end of the fiscal year.
There are 3 points I have in response. The first is, again, the remedies Congress, as much as this court or any court would want to provide relief, it's clear that it should come from Congress. My second point is that agency regulations have also implemented the congressional mandates of 1154A, and that's found in 22 CFR 42.33A1, which states, under no circumstances may a consular officer issue a visa or other documentation to an alien after the end of the fiscal year during which an alien possesses diversity visa as eligibility. And
right. Go ahead. Make a third point. Sorry.
The last point is just, there may also be a snowball effect in the time it might take for the State Department. Again, this is a zero-sum game with these interviews, and this is something State Department discusses with the prioritization guidance, taking away thousands of slots for previous fiscal years without, there just may be a snowball effect. Every year after that, there might not be adjudication of all the diversity visas available in every fiscal year. Would that entitle a reservation of 1,000 this year, 100 next year? Does the State Department always have to reach this 55,000 ceiling? No, nowhere in the INA, nowhere in this statute does it say that the State Department needs to meet this cap. These are the three issues.
Okay.
Am I correct in assuming that any of these plaintiffs or all of these plaintiffs could reapply?
They could reapply.
There's nothing that puts them at the back of the line.
They could reapply to the diversity visa lottery for.
So in other words, they wouldn't be put to the back of the line, but they wouldn't be put to the front of the line either. They'd just be in the random line in the same way that everybody else would be in applying for a current or subsequent fiscal year.
Yes, they could apply to become part of the program and then hope that they would actually be selected to become part of the program as well, to make that very clear.
Right. Yes, my colleagues have additional questions on other areas of the case.
Also,
I'm sorry, I didn't catch that. It's my mistake.
No, I don't. I'm sorry. I don't have any.
nor do I.
Okay, then Ms. Alsterbrook, maybe we'll give you some time for rebuttal. If you have any particular thing you want to conclude on, by all means do so, or if there's something you want to wrap up, do so. But otherwise, we'll hear from the other side and we'll give you some time for rebuttal.
Thank you, Your Honors. I'll cede the floor.
Thank you.
May it please the court. My name is Jesse Bless. I represent the appellees in this case. I want to talk about the three categories that Judge Katsas raised. I think that's an apt way to structure it. And we are in category 2, which was the prohibition, that they relied on a reading of a statute to stop, not just to deny, to stop processing and adjudicating wholesale visas. And even in the case that they rely on, Trump v. Hawaii, they recognize that the distinction between entry and visa issuance runs throughout the INA. And they cite specific examples of that, as do we in our brief.
They're not the same.
Can I ask you, I'm sorry, go ahead, Judge.
I'll go ahead, please.
Can I ask you sort of the flip side of the questions that I think we were putting to the government, which is, let's take the three categories. As I understood your argument is that an 1182F proclamation can never go to visa issuance. So that no matter what, the Secretary of State has to process visa applications and issue visas in the face of an 1182F proclamation, even if the president just decides in the proclamation and makes it as clear as day that there can't be any visa issuance during the time that this proclamation is in effect, because I see the problem of confusion that the government highlights, And I also think there's a sufficient unlikelihood that the issue that's leading me to issue the proclamation to begin with is going to be resolved. And so I don't want visas to be issued. You think that just can't happen under 1182F, or do you think it can?
Your Honor, that would be the category one, and our answer would be no. That we don't. It's not as if we can interfere with the president's authority under 1182F, but that extends to entry. And if we were to fall into bucket 3 on the discretion, and if there was indication in section, like, please exercise your discretion because this temporary suspension on entry is going to last for the foreseeable future, and assuming that deference was granted to the president, that would be really category 3, which I think which is where our position is. It's not.
Well, but if then you think that it's at least as a matter of discretion, the Secretary of State, and I assume that would have to mean the president, could decide not to issue visas during an 1182F proclamation.
But it's not about issuance; it's about eligibility, right? And I think that's a distinction. So,
if somebody's ineligible for a visa, then the visa can't be issued.
Right, and I do not believe the president can, in his authority to restrict the entry of a non-citizen and declare that suspension of entry an ineligibility for a visa.
Then what's the discretion then? Then you're saying there is no discretion. But with respect to visa, it only has to do with entry. There's just no discretion to stop visas under 1182F.
Not in 1182F. I think the Secretary of State, though, as an executive, cabinet member, has his own discretionary powers, and the government has provided the authority for that. I think it's 236. And
To do what?
Well, if there's
a visa can only be denied on a basis stated in law, in statutes or regs. So if 1182F doesn't shut down the visa processing, what else would? The whole premise of your argument is that but for the 1182F order, all of your clients were entitled to have their visas adjudicated and would have been held to be eligible.
Right. You cannot rely on 1182F. Say we have no discretion, we must stop.
So your answer to the Chief's question is president does not have an 1182F power to shut down visa processing, period, full stop.
That's correct.
Have nothing to do with discretion.
That's correct. And let me give you a real world example of how that had happened. And that was in 2021 in the Kinsley case, where there was a 14-day suspension on entry if you were from a designated country. And if the government's position were right and they had to shut down all issuance, that nobody would have been able to, go to a safe third country for 14 days and then effectuate an entry. And that's what happened. And when the district court...
I don't think that's the issue, respectfully, because there definitely could be situations in which it makes little sense to stop the issuance of visas. There could be. If it's a short time horizon, if it's likely the issue that gives rise to the bar on entry is likely to be rectified, then I think the president and the Secretary of State could well decide, as a matter of common sense and discretion, to continue the process of considering and issuing visas. But it seems to me there's also a flip side situation in which it could well be that it doesn't make a lot of sense to continue processing and issuing visas for all kinds of reasons. But you think that scenario just can't happen, that it's just not within the president's ambit to stop not just entry, but also the antecedent to entry, which is the issuance of a visa. That's just not something that exists, period.
It's not the statutory text. It's not. And the statutory text speaks specifically to entry, and then there are other provisions that speak to admission and eligibility for visas. And that runs throughout the INA. The Supreme Court has recognized.
And why doesn't the statutory text that says, or impose on the entry of aliens any restrictions he may deem to be appropriate? And before you answer, well, that says entry, it seems to me it is a restriction related to entry to restrict the visa in the first place.
Right. And I think I should back up. If you look at 1201, it presupposes that someone who's issued a visa does not always effectuate an entry, and that there are two different things, because 1201H and in 1201E, you have to surrender that visa, and you actually have, and you can be denied an entry even with a visa. So a visa does not guarantee that you are allowed to entry. And so we can give effect to all the words in the statute: entry, admission, and eligibility for a visa. And because we can, under the statutory, textual analysis, we should give effect to those words because Congress used them.
But Congress also wanted to give the president a lot of authority.
There is no question that the president has a wide authority under 1182F to restrict entry. But that is not this case. This case is about eligibility for visas. And eligibility for visas, not something within 1182F.
So can I ask, on the arguments pro and con for assuming it's mandatory or prohibitory? So you have best argument on your side is the structural one about 1182A versus 1182F. But I think a tough point for your side of the case is history. We have 100-year history of visa issuance. So can you cite me a single case in American history, pre or post INA, where a consular officer has said, I think there's some reason why this applicant is ineligible to enter, is excludable, but I am going to issue a visa nonetheless. I'm not sure it's ever happened.
No, I'm not aware, but I could go certainly do more homework on that. But I mean, that presents the novel question that this court is considering today, and that every court below it has considered as well and come out on the side of the plaintiffs in this case, which is it's presented here because what we had was, for the first time, something revealed, which was our reading excludes us from processing visas. And that was not an issue that has arisen before. And just because it's a novel issue doesn't mean that the court should ignore the plain statutory text.
No, but I mean, if you have 100-year history of visa, we're talking about visas, right? That's very strangely not a defined term in the INA, which defines a lot of terms, but there we are, right? So we look to its ordinary meaning. Maybe it's a term of art in immigration law. We look to the immigration law term of art context, and we look at that. You find 100 years of understanding that the purpose of the visa is to screen out individuals who are ineligible to enter. That's what a visa is.
But it's not a guarantee. And in our system, Congress has designed...
It's not a guarantee because you have a system of two screens. Right. You're saying the opposite. Right? It is, and eligibility for entry is a necessary condition of getting a visa. That's a different proposition from saying that getting a visa is a sufficient condition to enter.
What I'm saying is we have a system, 100-year history, where Congress designed this system such that eligibility for a visa, admissibility, bootability are different things, and they have different meanings. And throughout the amendments to the INA, since its, I guess, seminal statute in 1952 until today, 1182F has, at least for the most part, kept the word entry. And Congress has made the distinction, one that's recognized by the Supreme Court, that an entry and an issuance of a visa, two different things.
They are unquestionably different to the extent that they're done at different times and by different executive officials. But I can't find a single example where, I can't find a single example that defeats the proposition that at the visa, admissibility is a necessary but not sufficient condition for getting the visa on the front end.
No, because it can shift. It can shift both ways, and you want to have those different spheres. Someone could be issued a visa and it's valid for 6 months. And something could happen that could make them inadmissible after, right? So it doesn't always happen on the front end either. And that's why the statute is in Congress smartly has in 1201H, when you go and you present yourself for entry, you may have satisfied the conditions precedent, but that does not mean you're coming in. And so the argument for the plaintiffs in this case is that the statutory text can be read plainly and unambiguously. And it means different things. And when it can, there's no room for the government to rewrite certain provisions to mix in the word. And that's our position.
No, I understand. And you might win on the structure of 1182F, but if you're asking us to upset 100-year understanding, not necessarily, that makes it harder to accept that reading of text.
Yeah, and I can understand that, but if Congress was right for 100 years and it was being implemented wrong, it doesn't make it right.
Was there anything, was there anything in pre-INA practice like the 1182F proclamation, right? Which on your view is this one really special thing that governs entry but not visa issuance. Is there anything like that if I care about the history and look pre-1952? Hard question. I didn't see anything in the briefs one way or the other.
I don't, because I don't think we had a complete structure of immigration laws prior to it being codified. And actually, I think there was a federalist tension between states and the federal government about who was being allowed to enter. And then that shifted over. So I don't, sorry.
Can I ask you a question on the 1182F issue? You don't have to win, I don't think, but correct me if I'm wrong. You don't have to be right that the statute never allows for the exercise of discretion to stop visa issuance in order to prevail, because it could be that the statute does allow that, but here there was no exercise of discretion. Here, the assumption was that the 1182F order automatically, as a matter of law, means there can't be visa issuance. And that's just by hypothesis. The government obviously has a counter argument, but by hypothesis, that's just an erroneous interpretation of 1182F. And therefore, the orders, the policy guidances that are under challenge can't be sustained.
Yeah, that's exactly right. That was the point I was trying to make in the beginning, and I obviously did not do a good job of that. But that was, the argument was, it's not about discretion in this case. This case was, we are precluded from exercising discretion because this statute makes us shut off visa process.
Okay.
One other textual clue, which is, this comes from the INA definitions. We're talking about immigrant visas, which is a defined term, and it requires the recipient to be eligible immigrant. I think it's reasonable to say that an alien who is subject to an 1182F exclusion order is an eligible immigrant while the 1182F order remains in effect?
Yes, those eligibility criteria.
Immigrant surely imply, to be an immigrant, that surely implies entry, right? You can't immigrate to the United States without entering the United States.
Granted an immigrant visa and be deemed eligible for that without effectuating an entry. In fact, you have 6 months from the date of issuance of a visa, in most cases, to actually immigrate. And in fact, there are some people who are granted an immigrant visa who choose not to immigrate. And so your eligibility.
Sure, but eligibility means you satisfy all the legal requirements for getting the document or the status. And an alien under an 1182F order is not eligible in that sense.
That I disagree with. And that is where the statute runs into tension with that argument, because 1182F and 1201G do not talk, they talk in different spheres. And so when we're talking about eligibility, and it's either 1182A, which talks about inadmission and ineligible for visas, or other specific provisions where people are subject to terrorism bars and stuff like that. When we're talking about eligibility for an immigrant visa, and we're talking about a diversity visa, you have to satisfy certain requirements. You have to make an application. You have to satisfy an educational background. That is where that eligibility for a visa and application comes from. There are no more questions. I will turn it back.
I just have one question. I believe that you're handling the reservation issue too, the reservation of visas issue also. And
That's correct.
If we take out of the field of play al-Makrami, and let's just, I know you resist this, but let's just assume for argument's purposes that we accept the government's argument that actually that case was only about the jurisdictional question. It didn't go to the merits. It just decided that there was a non-frivolous argument, and then it sent it back, and now on the merits issue, it hasn't been resolved yet. Then what's wrong with the government's position that under the statute doesn't speak in terms of a limitation on administrative agency action. It just speaks in terms of eligibility. And it just says that eligibility ceases at the end of the fiscal year, and there's just nothing that anybody can do about it, whether it's a court, whether it's the secretary, it doesn't matter, but for obviously a subsequent legislation that creates a one-time carve-out. The statute just says what it says.
Right, but we're talking about separation of powers, as the government said, and there's a branch, Article 3, that gives federal courts the power, the equitable authority to effectuate remedies and make remedies where the law does not provide an adequate remedy. And the appropriations cases in this court is a good one, and I found one. And I was looking at that actually last night, and they talk about that, where there's sometimes where a court, to effectuate a remedy, has to use its inherent authority. And if the case is brought prior to a lapse or prior to a statutory deadline, then the courts have that authority.
Those are the best.
Oh, go ahead.
Go ahead.
No, please.
Those are the best cases for you on this point, but we have at least 3 pretty major pronouncements from the Supreme Court in the last 20 years or so. In Panaglinian, Grupo Mexicano, Oakland Cannabis, I'm sure there are more, saying that equity is not licensed to ignore statutes.
It's certainly not. And if the case just says in Gillian, if I'm saying that right, and just like in the Seventh Circuit case in Shahi, if the plaintiffs had brought this case after the statutory deadline, the courts at that point, maybe their equitable authority stopped, as courts have said. But because it was brought when it was, and the relief was granted prior to the deadline, courts are all on the side of the plaintiff.
Statute says
what in the statute?
Go ahead.
What in the statute draws that enables drawing that distinction based on when the case was brought?
The statute is not a jurisdictional, does not speak to equitable authority of courts. It speaks to eligibility. And so here what we have is if there's been a violation of law that has been, and there's an order of a court, that's not the statute that the district courts are relying on in this case. They're relying on its inherent equitable authority, which is from the Constitution, that a court has powers under the law and equity to, I mean, I'm paraphrasing, right wrongs, and to provide effective relief.
Right, but that could be the case even after the fiscal year elapsed if the claim were brought later, right? I mean, but I think you just said that if the claim is brought after the fiscal year elapses, then the plaintiff is out of luck. And I'm just wondering, what is it in this? Maybe it doesn't come from the statute, but is there something in the statute that says that line is one that courts should draw, or is that line coming from somewhere else?
I think courts, when it's looking at its equitable powers, have made that distinction.
As a matter of that's a matter of equitable discretion by the courts. Yes. I see.
And I hate to get into equitable principles, but it may be stemmed from latches, so that if you sat on your right and did not bring it in time, then the court should not then bend the equity principles and use its authority that way. Certainly not the case here. And I don't mean to concede the point that maybe that Judge Easterbrook was right or wrong. I'm just arguing for our case today.
Right. So and you don't resist the notion that you started with separation of powers, but of course Congress could enact a statute that's sufficiently clear that then that would preclude the issuance of relief after the lapse of the fiscal year.
Certainly could. But that does not mean that federal courts under Article 3 also do not share a balance of powers, and that they have equitable authority to do what they have.
Or it could enact a statute clearly allowing courts to leave open funds that would otherwise lapse, which they actually did in 1982.
Good.
So any of our post-1982 appropriations cases don't really help you.
Well, but there's one in, I believe, in 1977 that does.
Yeah.
And that's the one that, and that's why we're here. I mean, and I think it's a great point that the Chief Judge made about the Supreme Court review, because that's where Article 3 starts and maybe where it needs to end, where we would not have that ability. And again, there's, of course, other, I guess, judicial authority statutes, all Writs Act and things like that, but the equitable authority of the court that's inherent or stems from the Constitution properly exercised here.
We have a couple of cases pre-82 which help you, but that was an era when the Supreme Court and this court were somewhat looser in how we read statutes and remedies in a different context. And then we have 3 more recent Supreme Court decisions, including one in the immigration context, telling us just spot on, you can't use an equitable power to override statutory limit.
I understand that, but the context and let me talk about Pangilian first, because that case was actually that was discussed in one of the first cases where this reservation of visas was addressed. And in there, again, there was a specific statute by which the applicants or beneficiaries had to act, and they didn't. They waited years. And in the context of citizenship, actually, the Supreme Court and the Constitution is very clear about who gets to deem someone a citizen or not. We're not talking about citizenship here today. We're talking about court's equitable authority for people who brought claims prior to a deadline that is not jurisdictional, okay, and where a court has used its inherent authority to make a remedy where otherwise there would not be one. And in fact, the government in Elmer Kwame, I guess its other name, PKB Tillerson, actually conceded that issue. And they said courts had that authority. Today, you know, and in this case, they obviously have that right to change their position. But again, the court's equitable authority, something that both sides have recognized.
Let me see if my colleagues have any additional questions for you. I'm sorry, Judge.
All set, thanks.
Thank you.
Thank you, counsel. We'll hear from Mr. Arena now.
Please the court. Rafael Urena for appellate. Both in Gomez and Goodluck, the court found that both the March 2020 and November 2020 prioritization scheme, termed by the court as no visa policies implemented pursuant to PP 10014, were arbitrary and
Sir,
capricious.
could you tuck in the mic? I'm having a
Yes,
little
sir.
trouble hearing you.
The district court found that the department failed to account for the effect of those policies on diversity visa applicants and were premised on faulty interpretations of 1182F. The government today challenges those decisions. Committed, they state that the government begins this challenge on an expansive reading of 22 USC 2651A. They argue that this statute gives the secretary limitless discretion to administer the State Department as they see fit, and therefore the actions taken pursuant to that authority granted in the statute are unreviewable. But this expansive reading of 265.1 does not square with the statute, which clearly sets confines on the Secretary's administration of the department to the laws of the United States as implemented by the INA. This reading also does not square with the basic presumption of review in APA cases. The government has offered no compelling reason here to create an exemption.
What about consular non-reviewability?
Yeah,
This is all about issuance of visas by consular officers. So the consular officer had denied your clients visas based on the proclamation, based on priorities, based on anything. No judicial review.
there's no denial of a visa here at issue.
I'm sorry.
There is no denial of visas at issue here. There was no determination by the State Department of State to deny a visa by a consular officer.
This
The Secretary of State does not have.
This case is all about denial of visas based on the government's view of 1182F and it's creating priorities. And for the life of me, I don't understand the district court's distinction between, the district court said, well, if the government had denied the visas, no judicial review.
Correct.
But in fact, they just didn't process the visas because they thought they were legally prohibited from issuing visas.
That's correct.
What is that other than a denial of a visa?
Well, it's a broad stroke preclusion of it, finding of ineligibility, but that's not what a visa refusal is. A visa refusal is a decision by a consular officer at the time of application to refuse the visa. And then that's set forth in statute on how an application for a visa is made.
Suppose an individual consular officer had denied a visa saying 1182F prohibits me from issuing it.
Unreviewable, Your Honor.
I'm sorry?
That would be unreviewable
Right.
under consular non-reviewability. That's correct, but that's not what happened here. So if I had a client who brought a claim before this court saying that the 1182F refusal was in fact unlawful, this court would not have an authority to do that. But we're challenging an implementation of an executive order. That's what's at challenge here, not the actual refusal of a visa.
But the only bite any of this has for your clients is that they didn't get visas.
Well, they didn't get an opportunity to apply for a visa. They were precluded the processing of their visa application. That's really what's
which would have been denied based on 1182F, and that would be unreviewable.
But there was some waivers put in place that would perhaps given them the right to have a visa under that under the implementation of PP 10014 in both of PP 9984 and the travel ban. So it's not necessary that they would not have received.
Fair enough, but then the adjudication of whether or not the waiver applies would be unreviewable.
As to the specific one.
Right.
Yeah. Right, John. That would be unreviewable.
I mean, it just seems odd. I take your point that there is potentially a difference between the individual decision to deny the visa and a guidance document addressed to visas writ large.
Right.
Maybe that makes a difference. There are.
And the Ninth Circuit.
McNary is an immigration case where, individual decision versus policy mattered, but that's because there was something in the statute. I think it was the word determination. What is in this scheme that would cause us to think that even though any individual denial of a visa is unreviewable, we should nonetheless get into the reasoning of a guidance document that has no purpose other than to guide discretion in the granting or denial of visas?
Well, because there's meaningful standards in which to review that decision by the secretary, and those meaningful standards are found in the INA. So we can look the INA is a finely reticulated regulatory scheme governing the visa allocations, availability, and adjudication of visas. This isn't going beyond the actual adjudication, the processing of the visa.
Maybe for the 1182F piece of your argument, right? You got two potential problems. One is that all of this ultimately goes to visas and therefore into consular non-reviewability. The other is no legal standards, right? So you're right. The 1182F argument does not bump up against the no law to apply principle. It might bump up against consular non-reviewability, but we've talked about that. But why doesn't, insofar as you're challenging the guidance documents, the prioritization, what law do we have to apply to when the agency has all these different visa programs that they have to administer, and they're making decisions, they're prioritizing things in the middle of a once in a generation catastrophe?
Right. So we can look to the statutory expiration of the visa, right? And this is kind of the middle of the road where you and the Chief Judge have been speaking to, is that if they have some sort of discretion here, and then about whether to process visas or not, right? So then they would be whether there was a rational connection of what the determination made by the secretary, and that decision not to process visas would be the law to apply, and would be this 1154 statutory expiration of the visa. So the court can look to whether the decision made by the secretary was rational given that statutory expiration. There's also the section 1202B, which states that all immigrant visas must be adjudicated before a consular officer. And then in addition to that,
so that's fair. That is law to apply. And I guess I'm premising my question on your having lost on that question. If we adopt Judge Nichols' reading of 1202B, so you don't have a mandatory duty to process, akin to something enforceable through mandamus, and you're just back to the APA. Will we use the APA as a vehicle for assessing how the agency prioritizes?
If this court were to adopt Judge Nichols' reasoning that it was, I believe he used putting an elephant through the eye of the needle in that decision, right? So if we were to adopt that, there's also the agency policies themselves, which could be law to apply in this case. The FAM is also a very intricate body of policies and memorandas to run the State Department. So we can use government policies themselves also to review the decision by the secretary. The INA is one of the most expansive acts that Congress has passed. It sets out.
No doubt. But what in the INA guides Secretary of State's assessment of whether diversity visas are more or less important than other kinds of visas in the context of the situation on the ground in March 2020?
1151 states out the worldwide levels of immigration. So Congress set out some intent to have a certain amount of immigrants enter the United States every year. So we can look to what Congress intended for the immigrants to enter the United States.
You think that's a floor as well as a ceiling?
I think so. But at the very least, it's an intent that Congress said that the Secretary should make good faith efforts to allocate these visas and make them available to intending immigrants.
The level word is good for you in E, but in A, statute talks about a number not to exceed 55,000. Right, sounds like it's just a ceiling.
But there's some statutory interpretations in appropriation bills in Train v. New York where they say that statutory construction, in fact, means that they need to allocate those availability of those visas. And if the court doesn't have any more questions on that, I'll turn to the Ray remedy. The government challenged the Ray remedy turns on a single issue, whether 5 USC 705 permits a court to provide relief to non-parties when justice so requires. The plain language of Section 705 grants the power to issue all necessary and appropriate relief. The court's inquiry then must turn to what happens when agency action, and more importantly, unlawful agency action is invalidated. The court's inquiry then turns to the type of action challenged. The Ray suit does not involve a challenge of lawful policy applied unlawfully to a single group of visa applicants, rather but a challenge to the policy itself. In Ray, plaintiff sued challenging the unlawful cessation of processing and issuance of diversity visas pursuant to PP 9984, PP 10143. Those were COVID suspensions, quarantine suspensions. These proclamations precluded the entry into the United States of individuals who were in certain regions of the world for 14 days prior to their application for admission to the United States. Pursuant to those policies, the department ceased processing of diversity visa applications of affected visa applicants. When plaintiffs prevailed on their motion for preliminary injunction against the policies implementing those proclamations, the court forbade the policy's application not just to plaintiffs, but all diversity visa applicants injured by the agency's illegal actions. Therefore, those plaintiffs were likely to prevail on a claim that could provide remedy of programmatic relief. That affects the rights of non-parties. The logical extension is that under such circumstances, the court would need to maintain the status quo for non-parties and preserve the eligibility for visas to those non-parties. Therefore, the remedy is proper. And to support that, we turn to the Lujan versus National Wildlife Federation, Blackburn's dissent. And then lastly, we turn to the Filizopovich standing issue. The Filizopovich plaintiffs did not have standing under the claims they brought, but they did have standing under the theories brought by other cases consolidated in that. The court thus merged the cases and the common causes of action for all purposes under Federal Rule Civil Procedure 42A2 and 42A3. And that states that district courts enjoy substantial discretion in deciding whether and to what extent to consolidate cases, and may therefore consolidate cases for all purposes in appropriate circumstances. I reserve my time.
Thank you, counsel. Ms. Alsterberg, we'll start by giving you 5 minutes for your rebuttal.
I'd like to start by clarifying a point regarding the State Department's interpretation of 1182F that might also help shed light on some of the hypotheticals discussed earlier. The State Department has no discretion to issue visas absent explicit direction from the President in an 1182F proclamation. Without that language, the State Department and the plain language of 1182F and 1201G read together prohibit the State Department from issuing visas. The President can make the scope of a proclamation and determine that scope regarding visa issuance, but that is not at issue here. And again, in Trump v. Hawaii, the proclamation at issue there was found lawful by the Supreme Court. And the way that that proclamation worked was that the State Department did not issue visas in that case. The language of Kerry v. Dinh also supports this interpretation.
But that issue never came up in Trump v. Hawaii, right? There was not a question there about whether the State Department would have been right to conclude as a matter of law that it can't issue visas.
There was not, but again, to the common sense point, the proclamation at issue there was about the vetting systems in place in countries and to inhibit the ability for those individuals to get visas while those vetting systems were being determined whether they had posed national security risks. It would be inconsistent with that proclamation if the Secretary of State was then ordered to adjudicate visas for those individuals. And Kerry v. Dinh states, before issuing a visa, the consular officer must ensure that the alien is not inadmissible under any provision of the INA. And again, that would include 1182F. We can look to 1201G, and we can look at the language in 1101A16. I'd also like to just clarify my response to Your Honor's question about the visa lookout system and the individuals. In terms of how that precisely works, it's that the name of the individual will be pinged on the State Department's list.
So it will be, I'm sorry.
A ping shows up when that individual then is making the application for the diversity visa. So it's not the entirety of the list. It's the individuals that do make the application then show up on the State Department's list would be part of the visa lookout system and then would be identified as excludable.
So in other words, you can't name every alien subject to this proclamation and put them in the system. But what you can do is when an alien who is subject applies for a visa and then pops up on the State Department's visa system, you put that alien's name into the lookout program?
Yes. In terms of equity, to respond to some of the arguments on Oakland v. Cannabis, for example, that case stands for the proposition that equitable authority stops where Congress has spoken. 1154A makes it clear Congress has spoken. Eligibility ends at the end of the fiscal year, and courts have no equitable authority to extend it. So even if the court has equitable authority to reserve visas beyond the fiscal year end, it cannot extend the selectee's eligibility. There would be no one to issue those reserved visa numbers to. And indeed, expansive equitable arguments being made pose a larger question of where exactly would that equity end? Lastly, with regards to the points on prioritization, standing, and the 966 number ordered by the court in Ray, to prioritization, plaintiffs have argued that the fiscal year statutory deadline should weigh heavily in the Secretary's exercise of discretion on allocating consular resources, but more heavily than family-based immigration or additional United States citizen services. Congress gave the Secretary the broad discretion on how to allocate those resources. Plaintiffs may disagree on how the Secretary exercises that discretion, but it doesn't change that authority, and it doesn't change that in a circumstance like this, both under the plain language of 1202B that does not create some kind of deadline or time period in which that discretion must happen, and also to the reasonable use of the secretary's resources during that time period when, and continuing as consulates don't all operate at normal levels. That's what Congress gave the secretary the discretion to have, and that's exactly what the secretary did. The court in Ray went far beyond the bounds of what equitable authority, as already argued in general, but then beyond even that by providing relief to non-parties in the litigation, non-parties that were not before it. Even the district courts in Go and Goodluck noted that that kind of relief was far beyond it because there was no class. Ray is not a class action. Relief should not be provided to 966 diversity selectees when the Ray plaintiffs that remain were 9 individuals, 27 total, including their beneficiaries. It is a very large, expansive reading on equitable authority in that case. And with regards to finding that the Lazapovich plaintiffs had standing, the Clinton case makes clear that prior to consolidating cases, the district court still had to find that at least one plaintiff had standing. The district court in Lazapovich found that no Lazapovich plaintiff had standing, none of them. But then nonetheless, when it came time to consolidate those additional cases, it chose to wrap Lazapovich into it. With no standing, there's no jurisdiction. Those plaintiffs should not have been part of the consolidation.
Can I just ask you can I ask you one last question? I know you're over time, but let me just ask you one last question, at least for my purposes. On the prioritization issue. So I know that you have an argument that there's unreviewability, and I know you have other arguments too, but I just want to ask one question, which is that if we assume it's reviewable against your assumption, and we assume that the general APA standard applies, that the agency can't entirely fail to consider an important aspect of the problem. I know you think the agency did consider the fiscal year deadline and must be considered to have considered it given how obvious it is and how experienced the agency is. I take that point, but you don't dispute that the fiscal year deadline is in fact an important aspect of the problem.
Being aware of the very statutory text, yes, that is something to be considered. And Your Honor's point, the State Department is well aware of the long-standing components that make up the diversity visa program, including that deadline.
Okay. Let me make sure my colleagues don't have additional questions for you, Ms. Alsterberg.
So on that point, in order to rule in your favor, you have to either find the decision non-reviewable or conclude that you did consider that aspect of the problem.
Find that it was reasonable and a reasonable approach pursuant to the APA standard. There's nothing that was irrational or arbitrary or capricious given the COVID-19 pandemic and the status of these consulates around the world. For all of these reasons, this court should reverse the district court's order.
Thank you, counsel. Thank you to all counsel in this case. We'll take it under submission. Oh, we have to hear the cross appeal, I guess. So we're not entirely taking the case under submission yet. I guess we still have the cross appeal, my mistake. We'll hear from Mr. Cook now for cross appellants, if I've got that right.
That is correct, Your Honor. Charles Cook for cross appellants, the Go plaintiffs. Obviously, I've been sitting here for the last hour listening to the conversation. There's a couple of things that I think are important to note. Mr. Bless is right. 1182 has to be read as entry. Even though it's uncomfortable for the government to admit that they have been wrong for 70 years. But just like the Supreme Court said recently in the Nis Chavez decision, with Justice Gorsuch noting that words have meaning. And they said, yes, you've been interpreting how the notice to appear is wrong for the last 27 years. This is true here. It's just wrong. It just means entry. And yes, it does in fact mean that they have to have a visa interview. This is particularly important in the DV 2021 context. The DV 2021 lottery, the notification went out to winners in March and April of 2020, during the beginning part of COVID. Individuals began to send money to the Department of State in May, June, and July of 2020. At the same time, the Department of State is now saying they were unable to issue visas, and they could never issue those visas if that proclamation was extended in infinity. And that they kept taking money from people for something they're saying they would never be able to do. This goes to the remedy I'll talk about here in a second. But why would they do that? One, because they obviously knew there would probably come a time in which this prohibition under 1182 would end. Two, the department itself has authority under its own regulations to extend already issued immigrant visas for additional time should the individual not be able to enter the United States. And in fact did so in September of 2020 for people who had received the diversity visa prior to closure of consulates in late March of 2020, so they could enter the United States because they had not been able to enter during the initial period with barred travel. So the reality is, yes, they need to have interviews. And yes, if an individual was denied because of 1182, that would be unreviewable. But that did not occur here. And this goes to the exact relief that Judge Maida was talking about. How do you solve a problem, particularly for the DV 2021 plaintiffs, where government had knowingly taken money, had knowingly not acted for 5 months after they had lost 5 times on the issue of the meaning of INA 212F. 5 times they lost this. I know because I was the plaintiff's lawyer in 4 of those cases. And one in particular, particularly telling. In the Kinsley case, which involved visa applicants abroad who were barred from coming in under a separate proclamation because of COVID, coming directly from countries that had high COVID numbers, the court mandated the government issue those visas. Why? Because there was an option for them. In that case, they could go to a country that didn't have COVID or didn't have as bad a COVID. Here, the option is I can get an extension for 6 more months from the government. I can certainly do that. So what is the appropriate relief? Now, the reality is this is complicated. It's math, right? We all went to law school, not math school. And what do we do here? Well, this year for DV 2021, the government notified a relatively high number of selectees. The number of selectees vary year by year, but they're always based upon the statistical analysis of the Department of State. They have run this lottery for 30 years. They know that their intention is to use all the visas, and they've historically used most of the visas, if not all, and at least 3 times they've issued more visas than were eligible for the last 30 years. So they know we need to get to this number of selectees to get to this number of visas. And they obviously calculated the fact that COVID would have an impact. So we had a very high number of selectees, a total including family of around, let's say 130,000, a very high number. And you would say, well, only 55,000 of them can get visas. But we also know that historically, only about 41% of selectees end up getting the visa, historically speaking. Like 40% generally don't even apply. 39% don't even follow through after they win. Another 10% are denied actual visas. 10% are denied visas, and 5 don't show for their interviews. So you're around 40%. So 40% of 130,000 would have been about 58,000 people. As a result of Judge Maida's order, the department issued about 15,001 total visas, which left, as the court found, around, if you compare it to how many visas have been issued for family members, immediate relatives, about 76% of the numbers should have been issued. Our complaint and our appeal is this. Every one of our plaintiffs was motivated. They had complied with the law. They were ready for interviews. They had paid their money. They were among that 40%. When the judge found that only a third of them could apply for a reserved visa, it deprived 70% of our plaintiffs from the right to be able to apply for a visa when that became available, which is today. So our plea here today, and the reason for our cross appeal, is that Judge Maida was wrong only in his use of equity to help only a third of the active plaintiffs in our case. He should have reserved visas for each of the plaintiffs because each of them should stand an equal chance of receiving the diversity visa. Thank you.
Thank you, Mr. Cook. Ms. Alsterberg, we'll hear from you.
As counsel notes, there is too much math here. Equity does not allow for the concoction of back of the napkin decisions on how many diversity visas should be allocated. Why should plaintiffs be in a better position than the rest of the diversity visa selectees who are also affected by the pandemic in general? This does not make sense. Back to equity. This court does not have the equity to afford these diversity visa selectees a mathematical formula that extends their eligibility. Yes, the fiscal year deadline is clear. While this is not jurisdictional and is something that could be waived to allow the Supreme Court to review it, that's clearly not something that has happened here. The government has consistently argued that these individuals are no longer eligible to seek the diversity visas that they want. And to the extent that a remedy is available, it can come from Congress. Thank you.
Can I just ask one quick question? This does get to what we were talking about with the initial appeal, but since you flagged it, I just want to follow up. If it's the case that it can be waived in order to, or forfeited in order to create Supreme Court review, if that's true, then why isn't it the case that a court can do that too by ordering relief without regard to the government's waiver? I mean, it seems odd to me that whether that issue comes up is something that's entirely beyond the reach of a court acting on its own, and it just has to turn on the government's good graces to waive it.
The 1154A text does not impose a duty on the State Department. It just specifies the consequence of delay. And if the government asserts that 1154A, the statutory text, does apply, then a court is not authorized to substitute its own judgment for a different kind of belated agency action than the one chosen by Congress, which is the eligibility for those diversity visas expires. As the Shahi Court notes, relief would be forbidden by the statute in that scenario.
Okay. Make sure my colleagues don't have questions for you. Thank you, Ms. Alsterberg.
Thank you.
Mr. Cook, we're happy to give you 30 seconds for a very brief rebuttal if you'd like, but you don't need to take it.
Seconds, Your Honor. Thank you. We, in our relief in front of Judge Mehta, asked for every visa to be reserved that was unused. We did that because that's the fairest thing to do. And if the court wants to do that, I think that would be totally awesome. But at least our plaintiffs who took this fight on behalf of everybody else should have that opportunity. I will note one last thing. The president decided that immigrants were bad for America. Under the government's theory here today, he could issue a 212F order and say all immigrants are barred from the United States. Government's position here today is no court would ever be able to review that order, ever. Let's be clear, that's what we're really talking about today. And that cannot be the power from Congress, who created an immigration system, to give to a president. Thank you.
Thank you, counsel. Thank you to all counsel in the first case in the cross appeal. Now we'll take that group of cases under submission and we'll move to the next case.
Good morning.
Yeah, please proceed when you're ready.
Good morning, Your Honors. Nicolette Glazer appearing on behalf of the Gjoci plaintiff's appellant. May it please the court, I would like to reserve 4 minutes of my time for rebuttal. The Gjoci appeals comes to this court from the denial of a Rule 65A preliminary injunction. The district court did not address the merits of the claim pleaded, the APA and the equitable tolling, and did not weigh the Winters factor. The only issue the district court addressed was Article 3 standing, and that is the only issue that is before the court. We respectfully asked the court to reverse that decision because the court made 3 clear errors. First, although the court addressed the standing for purposes of the challenge to the 3 rules, the 3 rules, it did not address the APA claim pleaded by each individual regarding the denial or the delay in the adjudication of their accepted and pending DS-260 application. Second, the district court conflated the issue of standing with the merits of the claim. And third, the district court switched the burdens for purposes of the mootness inquiry from the defendant, invoking the doctrine, to the plaintiff, in order us to basically try to prove that the negative, that the government voluntary action after the initiation of the lawsuit did not moot all the claims. We respectfully submit that the decision of the district court was in contravention to clear Supreme Court precedent. Specifically, the courts have held that an individual who is being wrongfully denied an opportunity or has been aggrieved by an agency action has a cause of action under the APA to challenge and receive a review of that agency action. This is sufficient injury in fact, and the injury in fact here stems from the fact that each of these plaintiffs was the object of the government action. In Lujan, the Supreme Court made it clear that there is a difference in the injury in fact and whether that is particular and imminent, depending on who is the object or who is the actor that is inflicting the harm. When the object is, as it's here, the object of a government action directed to them directly, then there is no question that there is an injury in fact. Another theory of injury in fact that we raised before the court and the court sort of addressed, but the rejected, was what we dubbed the parity argument, an injury. And that is the fact that through these regular mandatory rules, the government had erected a barrier to the statutory relief. And under the general contractor's case and its progeny, the injury in fact in an unlawful government barrier is not whether the plaintiffs will receive a benefit, will be granted a visa or whatever relief, but it is that discriminatory impact that has created a disfavored group that has been treated differently. And the court below did not address that aspect of the injury. Clearly, the court could find on the merits that the government was justified in the delay or that there was no mandatory action to act, and as such, the plaintiff may lose the APA challenges. But as the Judge Easterbrook stated in the Shahi case, it can be difficult to fathom a more personal interest and a more real controversy addressing real people in a real way than when a person who has a deadline is trying to receive adjudication of a pending and accepted application. Again, the merits is something different. Here, the district court conflated the merit with the standing, and that is a reversible error.
Is there any difference, just on the merits, is there any difference between the arguments you're pressing and the arguments your colleagues are pressing in the Goodluck case?
The only difference, Your Honor, is that the Gjoci plaintiff pleaded the equitable tolling and estoppel claim, which is basically what we have argued in the Shahi case and which led Judge Easterbrook to find that there's no jurisdictional ground. There is no, there's not a mandatory processing rule, but is the kind of eligibility law that could be forfeited or it can be waived or could potentially be equitably tolled. Considering Irving and all the cases that have followed, there is a general presumption that Congress know that any deadline, unless it's jurisdictional, is subject to equitable tolling. Same is being done by court ineligibility. So what we have argued and district court did not address is that considering that these plaintiffs have been the object of an unlawful action, that is the full year diversity visa had been halved and 6 months were lost because of unlawful interpretation of 1182(6), is that a basis for a district court to toll the eligibility? And that is an argument for the merits that is for Judge Lambert to decide. That is the only aspect of the Gjoci appeal on the merits that is different. If the court does not have any other question, I will reserve my time.
Thank you, Ms. Glazer. We'll hear from the government now. Ms. Ramos.
Good morning, Your Honors, and may it please the court. Michelle Ramos on behalf of the government in Gjoci versus U.S. Department of State. This appeal stems from the district court's denial of appellant's preliminary injunction on the grounds that appellants lacked Article III standing to bring any of their underlying claims. The government notes that even if appellants had demonstrated standing, the end of fiscal year 2021 undeniably mooted this appeal, because in this case, the district court declined to grant any relief or reserve any diversity visas before the close of that fiscal year. This court should affirm the district court's denial. Appellant's underlying claims in this case brought 3 types of challenges.
Wait, can I just stop you for 1 second? So, because I think it sounds like you're transitioning away from moodness, and you started by bracketing the moodness point. And I just have a question about that. If, contrary to your argument that you just said was undeniable, I'm just going to suggest that it's deniable, at least for purposes of this hypothetical. Suppose that the end of the fiscal year doesn't necessarily preclude the ability of a court to grant some kind of equitable relief. That's the issue we've been discussing a fair amount already this morning. If that's true, then how does it make sense to draw a distinction between a situation in which the district court did grant relief and the situation in which a district court erroneously, by hypothesis, denied relief? Why would a plaintiff's fate rise or fall based on whether the district court got it right or wrong?
Your Honor, it would depend on the relief that was ordered before the end of the fiscal year in that hypothetical, setting aside the government's initial positions on what relief is available before the end of the fiscal year. Assuming that there was some relief available, that relief would arguably seem to come in the form of reservation. That did not occur in this case, but even if the court had reserved diversity visas, which was sought by the preliminary injunction in this case, the court has no authority to extend the applicant's eligibility beyond the end of the fiscal year. Congress
but I'm assuming that that's wrong. So I think unless I'm missing something, the government's argument throughout is that there's no authority on a part of a court to reserve visas because the end of the fiscal year divests a court of any authority to act. I'm just assuming that that's wrong. I'm just assuming that actually courts do have authority to reserve visas. And if that's true, that courts do have that equitable authority, and your initial position's wrong, then that raises the question, well, is there a difference between a situation in which a district court, as in the Goodluck cases, did reserve visas, and a situation like in this case, where the district court didn't because the district court denied relief? Of course, the district court doesn't reserve visas when it rules against the plaintiffs. And I guess my question is, how is that a meaningful distinction, a principled distinction to draw when the plaintiffs didn't do anything different? They just brought their claims. In one case, the district court agreed with them and reserved visas. In the other case, the district court disagreed with them and therefore didn't reserve visas. But if the district court, by hypothesis, was wrong to disagree with them, then how is it fair to say, well, in the one case, because the district court got it right, the plaintiffs can get relief. In the second case, even though the district court got it wrong, the plaintiffs are denied any possibility of relief. purely because the district court got it wrong. Now, I don't understand what basis there is to draw a distinction between those situations, because it just seems like it turns on the happenstance of whether the district court got it right or wrong. And that's something that's entirely out of the control of the plaintiffs.
Your Honor is highlighting the issue with the district court's employ of equitable authority for even reserving any diversity visas here. That is precisely the issue with the exercise of equitable authority here. Cases such as Oakland Cannabis have said equitable authority stops where Congress has spoken.
Right? Can I stop you for a second? I'll try one more time. And please, I know that you have a threshold argument. Maybe I'm missing something that you're getting to, and I apologize if I am. But I know you have an argument that it's wrong for the district court to reserve visas. I know that argument. And you have an argument that says that there's no equitable authority to do that because the statute precludes acting after the end of the fiscal year. I get that. I'm just assuming that argument's wrong. If you assume that argument's wrong and a district court does have authority to reserve visas, and I know you think that's wrong, but let's just assume for our hypothetical purposes that that's right. A district court does have authority to reserve visas, then what's the sense in drawing a distinction between a situation in which the district court exercised that authority and a case like this one in which the district court didn't because it ruled against the plaintiffs? It just seems to me that in both of those situations, the plaintiffs did everything they could do. So they should be equally situated regardless of whether the district court happened to reserve visas or not do so because it erroneously ruled against the plaintiffs. Am I making sense?
Yes, Your Honor. In terms of an alternative argument to whether or not, I think there is a tie between that reservation and eligibility. So to clarify, Your Honor is also assuming that the court can extend the eligibility. Is that correct?
Yes, I thought that was the whole point of reserving visas. Maybe I'm getting something wrong in the nomenclature or the semantics, but I guess my point is simply that the end of the fiscal year doesn't preclude the granting of relief. I'm assuming that that's the case, that the end of the fiscal year does not preclude the granting of relief. And in this case, the government's making the argument, well, look, but the district court they didn't reserve visas. So the plaintiffs are out of luck. And I guess my response is, why should the plaintiffs be out of luck just because the district court happened to deny them relief? If we think that the denial of relief was erroneous, then it seems like the plaintiffs are equally favorably situated as the Goodluck cases where the district court happened to reserve visas.
That would require this court to find that it can reserve diversity visas beyond the end of the fiscal year at this point. That is the juncture that we're at. So if this court were to find at this point that it has authority to resurrect fiscal year 2021 diversity visas beyond the end of the fiscal year, then yes, that would place the appellants in this case on par with individuals who had those
and I guess my question is why wouldn't we conclude that? Because we're already in a situation where somebody is reserving visas past the end of the fiscal year. The kind of happenstance of whether a court happens to do that before the fiscal year actually lapses or doesn't, it makes no difference to plaintiffs or to any principle of equity that I can understand, because the plaintiffs did everything they could. They brought a suit and they got a district court to rule before the end of the fiscal year. It's just in one situation, they got the district court to rule in their favor, and the other they didn't. And from the plaintiff's perspective, it doesn't make any difference. So I don't understand why a mootness argument would be more powerful in a circumstance in which the district court denied the plaintiffs relief than a situation in which the district court happened to grant them relief by reserving visas before the lapse of the fiscal year.
I don't think that the government disagrees that or would disagree with your statement that it is more powerful than in another case. The government's position would be this court would have to reach that beyond our threshold arguments, of course. But if we are sitting in that hypothetical position, then certainly reserve away, right? But here, fortunately, this court does not have to reach that issue. The mootness issue is a secondary issue to the issues that are before the court.
Yeah, and there may well be other very good reasons that you should prevail, but I'm sorry to have sidetracked you so long on that, but please proceed.
Certainly. Appellant's underlying claims brought three types of challenges. Challenges against certain of the department's policies and practices formally governing diversity visa processes, challenges alleging lingering effects of those policies and practices, and challenges against the prioritization guidance in place at the time of the district court's decision. On that first type of challenge, the district court correctly found that appellants lacked standing to challenge those policies and practices because those policies and practices ceased to exist months before appellants ever filed their amended complaint. Those policies, in total, the last date that any of them were in effect was the end of February 2021. Appellants filed their amended complaint on June 26, 2021. So for that reason alone, appellants lacked standing to bring those challenges, and any challenges that they brought, the district court found were moot at the time that they filed the amended complaint. For the other two types of challenges, the lingering effects and the prioritization guidance, the district court found that any increased risk of any particular appellant not receiving a diversity visa depended on other factors, not just those challenged policies and practices or the prioritization guidance. It also depended on whether the individual was documentarily qualified, the regional rank order of the particular individual, conditions at the embassy or consulate. And appellants failed to demonstrate that any of those other factors were not a reason for the delay or withholding that they allege here. And I recognize that my time has expired. For these reasons, the district court correctly found that appellants lacked Article 3 standing to bring any of their claims in any of those three types of challenges, and this court should affirm its denial of appellant's motion for a preliminary injunction.
Let me make sure my colleagues don't have any additional questions for you, Ms. Ramis, sorry. Thank you, Ms. Ramis. Ms. Glazer, we'll give you, I believe you still had 4 minutes left. We'll give you your 4 minutes.
Thank you, Your Honor. Very quickly on three arguments that were made. First, I respectfully disagree with my colleague. There is nothing in 1154A that speaks of the authority of the court. The Supreme Court has said the only time there is a question that goes to the authority of the court to do anything is when the statute says so. There is nothing in 1142A. Also, this is not a mandatory processing rule. There is nothing about us bringing a claim or how to bring it, where to bring it. So the only issue with 1154A is the question of eligibility. And eligibility is a question that can be extended if there is a violation. And it goes to the principle that Blackstone identified. In his commentary in 1803, it says it is well settled, an inviolable principle in the laws of England, that every right, when withheld, must have a remedy. And here, contrary to the argument that are made about the lingering effect and the substantial increase, we have undeniably a 6 months that were taken away from the eligibility of these plaintiffs. The same provision that the government is counting says plaintiffs are entitled to the benefit of an approved petition for a duration of the fiscal year, and that is 12 months, or when the cap is reached. No question that the cap was not reached. And so what we have here is that 6 months were lost. Nothing was done during this month. Now, what's relevant is that in this particular case, and the district court found, two of the plaintiffs, Mr. Pun and Mr. Donai, were eligible, meaning they were documentary qualified, they were current on October 1st, day one of the year, then one of the DV 2021. And yet, they did not get scheduled. Nothing was done on their cases for 6 months. We respectfully submit, when you have a benefit program that is a duration established by Congress, and you cut it in half, it is understandable that the risks are substantially increased, at least by 50%. When KCC was not making slot available for DV, when it was making those slots available to other categories, that necessarily pushed every DV applicant down the road. And that is the standing for the pan. Now, Ms. Ramos illustrated that the district court said, well, the pandemic excused that, but that's a merits question. That's not a standing issue. If the plaintiffs have a real interest, personal interest in the lawsuit, then the court must assume the validity of their claim for purposes of standing. The Supreme Court has warned that the eligibility for the ultimate relief must not be grafted onto the standing inquiry. The second argument I would like to make is that If the court is to find that the district court was wrong, then the notions of equity such as laches and estoppel will prevent the government from claim, well, regardless of the fact that you were wronged, regardless of the fact that you made all the efforts to bring a decision, you will be losing because of the end of the year. I believe the estoppel claim that we specifically made that goes to that point. If the court is to find that the government has acted unlawfully, then the court could provide or prevent the government from asserting on a position that is contrary to what they previously have asserted. And for that reason, we respectfully ask the court to find that standing was present as with all the other cases, and then return it to the district court to make a decision on the merits of the plaintiff's claim. Thank you, Your Honors.
Thank you, counsel. Thank you to both counsel. In this case, we'll take this one under submission as well, and we'll move to the last related case. Ms. Greenberg, please proceed when you're ready.
Thank you, Your Honors. May I please the court? My name is Julia Greenberg, and I represent Antanina Serakova, the appellant on this case. The court reviews the issuance of a preliminary injunction for abuse of discretion. On September 26, 2021, the district court denied Serakova's motion for preliminary injunction. Honorable Judge McFadden abused his discretion when he ruled that Serakova has failed to show likelihood of success on the merits on her claim and irreparable injury. In deciding motion for preliminary injunction, the court must balance 4 factors: movement's likelihood of success on the merits, irreparable harm to the movement, whether an injunction would substantially injure other interested parties, and whether the public interest is advanced by the injunction. In applying the 4-factor standard, courts employ a sliding scale under which a particularly strong showing in one area can compensate for the weakness in another. Therefore, the court may issue injunctive relief upon a particularly strong likelihood of success on the merits, even if there is a relatively slight showing of irreparable injury. Not to repeat the same arguments heard this morning from Goodluck and Gjoci's attorneys, all of which Serakova joins, I would like to emphasize the following. The Congress has not given executive branch the power to change immigration laws or decide which category of immigrants should or should not be adjudicated. Again, I want to emphasize, not given visas to, but adjudicated. Congress also enacted Section 1151E of Title VIII to provide 55,000 diversity visas each year to people from countries with low level of immigration. And why did the Congress do it? Because it intended to diversify immigration system as opposed to having influx of immigrants from particular countries. Again, this is the will of the Congress that we are talking about here. One of the requirements of diversity visa applicant is that they have to be educated, healthy, lack of criminal record, and not a threat to national security. And I'm oversimplifying this. But the point is that this is a very low bar considering to other categories of immigrants that Congress gave opportunity to apply and immigrate to the United States. In denying Serakova's motion for preliminary injunction, the district court essentially agreed with the government's argument that Department of State's prioritization of family-related visas over diversity visas was reasonable, despite the fact that family-related visas have no expiration date and diversity visas do. The court reasoned that immigrants with familial tie is in better position for preferential treatment by the Department of State than Serakova, who, by the way, she's a professor. She now resides in Poland. She teaches art at the Berlin University of Art. So I would disagree that she's in worse position than immigrants with familial ties. Respectfully, police or the government is not empowered by Congress to discriminate diversity visa applicant this way, especially since diversity visas have congressional deadline and others don't. And this court in Bars Barlap's Inc., it's 930 F 2nd at 74, held that where agency has manifested bad faith by asserting utter indifference to congressional deadline, the agency will have hard time claiming legitimacy of its priorities. And this is exactly what happened here. By statute, the executive branch is obliged to process and adjudicate diversity visa applications at the same speed and same volume as other visa categories. In opposition to Serakova's motion, the government partially blamed COVID for the shutdown of the Kentucky Consular Center for almost half of the fiscal year. This argument is not supported by the fact in this case. Kentucky Consular Center was created on October 25th, 2000, solely to speed up processing of diversity visa application. It is located in Williamsburg, Kentucky, and unlike many posts in foreign countries, which had to abide by strict COVID foreign restrictions, Kentucky Consular Center had no reason to stop its operation for almost half of the fiscal year. All U.S. agencies, including USCIS, National Visa Center, continue to operate. Unlike many paper-based immigration forms which USCIS continued to process during COVID, diversity visa application is an online form. Essentially, all that Kentucky Consular Center has to do, their employees have to do, is to review online applications and documents and confirm that the applicant is documentary qualified for a visa interview. Direct Mile, in charge of the Kentucky Consular Center, submitted a declaration in opposition to Serakova's motion, where she provided no reasonable justification for the shutdown of the Kentucky Consular Center. In its denial of Serakova's motion for preliminary injunction, the district court hasn't addressed Serakova's argument that the government unlawfully withheld adjudication of diversity visas in violation of Section 1201B and D, Title 8, which states that all immigrant visa applications shall be reviewed and adjudicated by the consulate office. It is clear from the argument presented by Sarakova that she has shown strong likelihood of success on the merits. She has also shown that she would suffer irreparable injury if the court wouldn't reserve her visa past 2021 fiscal year. To satisfy the irreparable harm requirements, Sarakova must demonstrate that absent preliminary injunction, she will suffer an injury that neither remote nor speculative. The harm doesn't have to be severe, but simply imminent, and one cannot be remedied if the court waits until the end of the trial. On September 30th, 2021, Sarakova forever lost her chance to have her immigrant visa application processed and adjudicated by the government, and her mandamus action became moot. In PK versus Tillerson, the district court granted injunctive relief to plaintiff in light of the potential irreparable harm that they face for not having their visas adjudicated. Sarakova is essentially in an identical situation, and plaintiffs in PK and the government hasn't appealed that decision. In denying Sarakova's motion, the district court reasoned that since Sarakova was not entitled to visa, but simply its adjudication, she was not harmed. Respectfully, Sarakova is not suing the government for refusing her visa, but for the willful refusal to adjudicate it pursuant to the US statute. If court sides with the district court on this issue, then all immigrants will lose their chance to challenge the agency's wrongdoing on visas that have expiration date, because immigrants are never entitled to visa. They are just entitled for the government to adjudicate them. So the government will forever become immune from the challenge on this issue. And lastly, I would like to point out that the last two criteria for preliminary injunction also favor Sarakova. The balance of equities and the public interest merge in cases against the government. In League of Women Voters v. Newby, this court stated that there is a substantial public interest in having government agencies abide by federal laws that govern their existence and operation. Absent a grant of preliminary injunction of Sarakova's case, the government unlawful action alleged earlier today would be left without the court review because Sarakova's case is now moot. I have nothing further.
Thank you, counsel. Let me make sure my colleagues don't have questions for you. We'll give you a minute for rebuttal.
Thank you.
Mr. Wellen, we'll hear from you now.
Good morning, Your Honors. May it please the court, Will Weiland for the United States. This case is distinguishable from the other cases you have heard thus far this morning in that it involves the denial of an emergency motion for a temporary restraining order and preliminary injunction brought by a single plaintiff. Ms. Sarakova, the appellant, is a Belarusian national who was selected to participate in the diversity visa program for 2021. And in her supporting paperwork listed her residence in Moscow.
You have distinct arguments on irreparable injury, but is there anything distinct on the merits between this case and the others we've heard?
Yes, Your Honor. Setting aside that if you agree with the government's position on whether or not a visa can even be reserved in the mootness, on the merits, the court, and I will say that this court should still affirm the court below because the court didn't rest its decision solely on reservation, but went on to assess the winter factors as it's appropriate, and specifically found, importantly, on winter factor 1, Ms. Sarakova was unlikely to succeed on the claim.
Well, that's what I'm saying. I mean,
Yes,
let's say you win Goodluck on the government's position in that case. Is there any more work for us to do here?
But sir, if you agree with us on the position
on the merits, in the other cases.
No, Your Honor, but I would say this case doesn't involve a policy challenge to the State Department's implementation of any president.
I understand. It's narrow.
Yes, sir. It's only an unreasonable delay in mandamus. And the court found that that Ms. Sarakova, as was her burden, had not shown that any policy of the State Department affected the processing. And so I think that's a distinction. The court also found that if there was any delay, it was attributable to two primary factors: the COVID-19 pandemic, which quite a bit about, and is in the record quite extensively, and also then the actions of the Russian with regards to the embassy. And for that reason, she was unlikely to succeed on the merits of her claim. The court also assessed the important winter factor 4, which is what would relief do with regards to other agency priorities, and found that Ms. Sarakova had not demonstrated that advancing her case, prioritizing her case over everyone else who was pending interview at the embassy in Moscow was merited based on the showing she had made on September 26, 2021. And as a result, he determined he would not grant the relief to Ms. Sarakova regardless of the issue of reservation. If this court, I'm happy to rest on my brief or answer any questions this court might have in that regard. And also belabor the issue, if need not do so.
Thank you. Thank you, Mr. Wellen, unless my colleagues have questions for you. Thank you. Thank you, Mr. Wellen. Ms. Greenberg, we'll give you 1 minute for rebuttal.
Thank you, Your Honors. I just want to remind the court that, again, for preliminary injunction, it's a sliding scale. So if the applicant shows strong likelihood of success on the merits of the likelihood to prevail on the merits of the case, then she can only show a slight likelihood of irreparable injury. But in Sarakova's case, and I emphasized this during the oral argument before the district court, she's not a national of Russia. When she, in 2020, when she was selected for DV visa application and filed it on September 30th, 2020, it's literally the first day of the fiscal year, she was residing, she's a national of Belarus, she was residing in Russia. So when she moved to Ukraine, remember the Kentucky Consular Center, she completely shut down its operation. So she tried to contact, and by the way, the Kentucky Consular Center is the only center who could change the location of her visa, of her interview. So she tried to contact, there was no response. The Kentucky Consular Center even shut down the phone line. So all email inquiries had to be made through email. Obviously, no response followed. And in July, when she retained myself, I emailed the Kentucky Consular Center and I asked to be transferred to Poland consular post. But I don't think it excuses the government's, even if Serakova's case was in Moscow, the government could transfer by its own volition the consular post from one country to another, as happened in Ukraine when the government could not operate the consular post in Ukraine. It transferred to Germany, Frankfurt, where it could continue to process and adjudicate immigrant visas. So I don't see the reason why that would excuse the government from adjudicating Serakova's case. And this is all, Your Honors, and Serakova respectfully requests that the decision of the district court be reversed and should be granted relief requested. Thank you.
Thank you, counsel. Thank you to both counsel in this case. We'll take this one under submission as with the other cases.
Thank you.